find definition of law, find definition of the school of thought, and then that's all. Let's listen to another person so that probably you learn what we're talking about from that individual. Yes, good afternoon.
Good afternoon.
Yeah, good afternoon.
So I just finished. So I want to snap mine. But what I wrote was I explained the school of thought. I explained nature law and positive law because those are the ones I'm very familiar with. I explained nature law that it shed nature law was shed more light by Thomas Aquinas. He explained it as it being it was brought by God, who is the ultimate creator of all. It's all about being just, right, and fair. And I also said the scholars believe that for society to be peaceful and for there to be peaceful coexistence, humans or individuals must be just, fair, and right in our activity. This is just like a brief of what I wrote. Then positive law, I said said something about it being imposed, the rule being imposed by what they call it, rulers who have sovereign power. I also mentioned two weaknesses of each. Those are the two I'm very familiar with. I was in the class.
All right,
I want to snap mine very fast, so I just
Elijah,
that's why I'm giving it. Let's over.
Okoyemi Elijah, yes, let's hear you. What was your answer like? How did you attempt that question? Clinton or Dewano, you want to speak?
Yes, sir.
Yeah, go ahead.
I first attempted this question by looking at the natural law school and the legal realist law school. So the natural law school, I mentioned the people who are part of the natural law school. And I also mentioned people that were part of the realist law school. I also mentioned the weaknesses. One of the weaknesses is that it is subjective and it is dependent on reason. Then for the realist law school, I mentioned that it was focused on judges and it undermined the rule of law. So I'm done.
Okay.
Good evening, sir.
Yeah, good evening.
Good evening, sir. Yes, sir. I tried sending my answers to your Gmail, but it's saying it does not exist.
Well, maybe you are typing the wrong address. Yes. Anyone wants to give us answer?
Yes, sir.
Yes, go ahead.
Sorry, can you hear me, sir?
Yes, I can.
So the way I answered mine, I started with the definition, then I went on to explain it the same way the scholars who read about the school of thought on how they also explained it. The school of thought I talked about were the historical and the natural school of thought.
Okay.
Then I went on to also give the weaknesses for all of them. Then I mirrored them with Nigeria, basically, and that was how I ended it, sir.
Yes, Suez.
Good evening, sir.
Good evening.
Yes, I am. I started with the most familiar school of thought, which is the historical law school and the realist law school. So the realist law school, I said this school of thought is divine law as a product of historical development. They believe law is a spirit of the people. That is, it binds the people of a particular society and distinguish them from the society from other people. An example of a historicalist is Cavon Savne. And also, I went on to list the weaknesses, which is the question of how long the people must engage in a practice to be taken as law, and also the issue of the spirit of the people. And also, moving to the reality, I said people of thought defines law as what officials do about this, and I think there's only one witness, which is it focuses on the court system. Thank you, sir.
All right, thank you for that contribution. Yes.
Good afternoon, sir.
Good afternoon.
So I talked about the way I approached my question. The two school of thought I talked about was the realist school of thought and the utilitarian school of thoughts. So I said the realist school of thoughts is based on the court's judgments, whatever the judges or the courts or the interpretation they give is the law. And also the utilitarian school of thoughts, it talks about the happiness, the greatest number of the greatest number and greatest how do I put it? The happiness of the majority of people shall. Talks about the greatest majority and what the happiness and the greatest majority. And I talked about their weaknesses too, like for utilitarian school of thoughts, the minority is not considered, only the majority is considered. While for the realist school of thoughts, the only the courts makes law and no other can make law. Thank you, sir.
All right. Any other person?
Good afternoon, sir.
Good afternoon.
I talked about the historical school of law and natural school of thought. For the history, I talked about the fact that it believes that the law should represent the history of the people, and by doing that, I made the example that I gave in class where he talked about the practices of homosexuality that is not accepted, and since the history of the people do not practice it, so it cannot be accepted by law. And philosophers under this historical school of thought are Carl von Savny and Gustav von Hugo, sir. Thank you, sir.
All right, thank you. Yes. Any other contribution?
Good afternoon, sir.
Good afternoon.
Well, I actually discussed on the positive law school and the utilitarian law school.
Okay.
The positive law school, I stated that this school of thought based their power on the sovereign as the highest, like they base the power of the sovereign as the highest power in the country. I said, who's the sovereign? The sovereign is the highest power in the land and has the right to give laws to the people, to the inferior people who must obey the laws or suffer punishment. I stated their perspective that this positive school of thought believed that without the sovereign, there would be anarchy and lawlessness in the state. And this law school makes sure, this law school is different from the natural law school, which makes sure that there is justice and fairness. The positive law school only focus on what the sovereign says and nothing else. And what the sovereign says is law according to this according to this school of thought. So I mentioned some exponents like Thomas Kelsen. I said Thomas Kelsen. Thomas Hobbes, John Austin, and House Kelsen. And I also stated that John Austin described law as a command made by the sovereign on a group of inferior people who have no choice but to obey or suffer punishment. Their major weaknesses are number one, they do not restrict the sovereign's power. That means there is no restriction to his exercise of power. He can easily misuse it to his advantage and the people of his kind. And there is room for dictatorship because this, with little or no check or balance, there is tendency for their sovereign to become a dictator like Adolf Hitler. So, and the utilitarian school of thought, this one, they base their ideology that as long as the people are happy, that the law is okay. Like they base it that as long as people are happy, the law is okay. And this may seem fair and okay at first, but when you check it, you find out that what of the minorities, they also have a right, they also have a say. So the major exponent I was able to remember was Jeremy Bentham. And this utilitarian school of thought believe that pain and pleasure are the guiding forces of our human existence and our human control. And their major weakness is, of course, that they do not consider the minorities. Thank you, sir.
All right, thank you very much. I've listened to everything that you said, and you've done well, but if this is to be subjected to examination grading, especially based on various submissions you made, your
I
mark
can't hear you, sir.
your mark will not be something that you'll be proud of at the end of the day. Now, I'll need to guide you through in answering questions like this. Any question that you are asked to provide answer to, there is always need for you to provide a short introduction to the question. Especially now we're talking about law. We're talking about definition of law. And one of the things you can begin with is by stating that, yes, law is a very important instrument in the society, and then that attempts to define law has, been met with some form of difficulties because of probably the nature of law as a concept. And then you try to provide a definition from your own view. And outside that, you go further to provide definitions that various scholars have advanced in time past. You look at some of this, according to Herman Klockman, this is what law is. According to John Austin, this is what law is. But as beautiful as these laws may be, they have one criticism or the other. And then you go further to talk about the general definition that has been given to law. And you recall, if you follow the class properly, that we did say that law can be referred to as a rule, or it can mean regulation. It can also mean the whole reservoir of rules of a particular society. And then you dovetail into this. The existence of the school of thought basically is to further provide answer to the question, what is law? Because for those of us that follow the lecture properly, you will discover that it was after we have generated definitions for law, we have examined the definition as proposed by scholars, that we took a step further to look at the various views as expressed by this school of thought. Then you need to tell us what the school of thought means. Then it is your duty to mention also that, having said all of this, you will examine two of the school of thoughts and start by listing them, either the historical law school or the natural law school. You can even go ahead to state that we have about close to about 3 or 4, but your emphasis will be on 2. You list the school of thought. And as you pick each of the school of thought, you let us know what definition the school of thought has provided for law. Outside that, you need to also state the features of this particular school of thought. Then you dovetail into those scholars behind this school of thought, which we popularly refer to as exponents of the school of thought. There's nothing wrong if you let us understand the reason why some of these scholars share the same view, which we have established severally in the course of our lecture, that it is either because of their experience, because of their profession, or because of their religion. But whichever way, you still go further to tell us the weaknesses of this particular school. Once you have done that, you now begin to draw your conclusion. And one very safe conclusion to draw on this is that the effort to provide a generally accepted definition of law is still ongoing. And having looked at the this school of thought, it is stated that none of this school of thought is better than the other in terms of the proposals they have made in defining law. While you make that argument, you also need to state that, yes, none of them is better than the other, and no one is entirely wrong, even though they share different views. Some share the view that a law must favor the majority of the people in the society. And then we argue that, oh, does it mean that the right of the minority are not important? What about those who talk about the historical law school, who is of the view that law must grow from the way of life of the people? And we query that, for how long will a particular custom exist before it can crystallize into law? So, despite their proposition, despite their submissions, despite their weaknesses, none of them is entirely wrong. And then you can conclude with that, the fact that there is no particular definition, but that law is generally described as this, and that it is better to describe law than to define it. If you can provide your answer like this, it will be difficult for you not to have the maximum score on a question like this. So this is supposed to be a model for answering a kind of question in this form. You must show in your submissions that you understand what is it is that you are writing. There's no way you make this submission and your lecturer will not see that indeed you know the subject you are dealing with. Okay? So that's the kind of answer that is expected of you. So if you have not provided an answer in that form, then I think you still have a long way to go in studying what we have been taught. Because if you have them, if you have the stuff, you have the fact with you, it will be easy for you to write them. Okay? So on that note, I will take one or two questions regarding the responses that are provided, and then we can close for the day. Any question? Any question?
Yes,
Yes, I
sir.
have a question.
Go ahead.
Yes. Sir, like the Supreme Court of Appeal said in the last time, said just replaced with the civil and criminal. If it was replaced, how
I'm
come it's still
asking
existing?
question about the test you just wrote. Okay?
Oh, sorry,
You
sir.
can
I
ask
read
me your other question in another class. But I'm asking whether you have a good understanding of the model of the answer I provided for this kind of question. That's what the floor is for. Okay? All right. So there's no question. I will say yes.
Good evening, sir.
Good evening.
Sir, for this test that we just wrote, is it possible for you to probably show us something or probably tell us something that we could use as that we could see as an introduction that we could write as an introduction, just like so we can like understand it more. I don't know if you understand what I mean.
Did you listen to my review of the question? Did you listen to my kind of answer to the question? Probably you didn't join on time. I gave you an idea of what your introduction should look like. Okay, let's take Dante.
So what's the mark for the test?
I can't answer that kind of question. That is exclusively for me. All you need to do is what you have done, okay? All right, so we stop there for today. I believe you've learned one or two things that will be useful for you in future. So take care and enjoy the rest of your day. So when we reconvene, we will take the lecture off from where we stopped in our last class. Thank you very much.
Sir.
And enjoy the rest of the day.
Good evening, sir.